gonna get your whole office here? No? Okay. All right, hold on. I got one more person who might be here to observe, so let me get him connected. Tim, because I don't have any Tims. No. I sent a chat message to Tim. Tell him to connect. Anybody know a Tim that might be logging in? No.
Well, I'm logged in under John, the one with the ceiling. Sorry, I got my hat on and I didn't want to be disrespectful to the court. So I'm coming in out of the field.
There's somebody else. Okay.
Okay.
I'm not going to wait for them to connect. I've sent them instructions. So this is in the matter of, check. Got everybody here. SSP Leasing LLC and Cambridge Lake LLC versus Cambridge Township, Cambridge Township Board, and Cambridge Township Planning Commission. File number 23-237064 CZ. I have Philip Goldsmith, P37650, appearing on behalf of the plaintiffs. And then I have David B. Landry, P32055, appearing on behalf of the defendants. I don't have your name, Mr. Lucas.
I'm just co-counsel. I represent the city of, I'm the township of Cambridge, but as local counsel. Mr. Landry is chief counsel.
Okay. And then I have Frederick Lucas appearing as local counsel for the township of Cambridge. So this is the date and time set for a pre-trial. Mr. Goldsmith, Mr. Landry, Mr. Lucas, how do you wish to proceed today?
Judge, I'll start out. Can you hear me okay? I noticed you had trouble with some of the other litigants.
No, I can hear you just fine. That was just them. That wasn't.
Okay. Yeah. I'll use my outside voice.
There you go.
So we have recently met with Mr. Lucas and actually one of the representatives of the citizen opposition group in this matter. And some settlement negotiations have been initiated. None of us know, obviously, where that's going to lead, if it will be fruitful or not. But we have initiated that process. And that's one of the things that is happening in this case. The other equally important thing that's happening in this case is that the Cambridge Township Board of Trustees adopted a new mineral extraction ordinance. It's a police powers or general code ordinance that regulates mineral extraction within Cambridge Township. If the court might remember that the lawsuit was filed just after a moratorium was declared by Cambridge Township, the purpose of which was to adopt this new mineral extraction ordinance. Up until that point in time, or we would say we have fully complied with the zoning ordinance of Cambridge Township in terms of our conditional use approval permit for mineral extraction. We are cognizant of the fact that they now have a new ordinance. I've had discussions with both Fred and David today, as a matter of fact, and they're going to provide us with an ordinance. All we have to date is an ordinance that's stamped draft. And David Landry and Fred will provide us with an ordinance that is the ordinance that's actually been adopted by the township with the date of adoption, I assume the date of publication, and the effective date. So with that said, and these two tracks will run simultaneously or concurrently, settlement negotiations will continue, and we are going to supplement our existing application, mineral extraction application, with what the township is requesting us to supplement it with based upon their new police powers ordinance or general code ordinance. Now that's going to take some time because we have to have our experts, our consultants, do some additional work, submit that to the township. The township will have, will complete the process that had been previously started with respect to the public hearing on the conditional use permit application. They will make a recommendation to the township board. Then the township board will either say yay or nay based upon the Zoning Enabling Act and the Cambridge Township zoning ordinance and mineral extraction ordinance. We will then have exhausted all administrative appeals or all administrative measures. So long story short, I've talked with Mr. Landry about this. We are going to ask the court to set this for another pretrial in June because either A, the case will be settled, in which case we would let the court know, or B, we will have hopefully exhausted all of our administrative remedies by going through the process with respect to the adoption of the new ordinance. So I want to keep the case live if the court will do that. Mr. Landry has no objection to that because we want all of our rights preserved that were filed in our initial complaint.
Okay. Mr. Landry, any objection to a pretrial in June?
Your Honor, I don't have any objection. I've had discussions at length with Mr. Goldsmith because the original application had never been fully decided because the moratorium was put in place. He's correct that they do need to exhaust their remedies. There's a new ordinance, and so they're going to supplement that will have to work its way through the township. I guess there's two options. We can dismiss without prejudice and they can restart if necessary, or plaintiff would rather just have this case carry if the judge carry on. If the court wants to set up another follow-up, I have no objection to that, Your Honor, as long as if we appear before you in June and for some reason the township does not approve it, I sure would not want to face a shortened discovery period because the case is a year old by that time. That's all I'm going to say. Otherwise, I have no objection to a follow-up pretrial.
All right, Mr. Lucas.
Well, Mr. Landry is actually in charge of the case, so I'm going to defer to his wise counsel on this matter. The only thing I would say is, as it relates to Mr. Goldsmith's comments with regards to the application, I just want to say that his client will have to supply all of the requirements as specified under the new zoning and new regulatory ordinances regarding the mining before the township can move forward on considering that application.
Okay. Miss Adams, do I have June 17 available for pretrial?
You do not, Judge.
I do not.
You do not.
Awesome. How about June 10th? That means I'm going on vacation. So.
You are not available that day.
That's not a vacation. How about June 3rd? Oh, I know why I'm going. June 3rd?
3rd is good. 1:30?
June 3rd until at 1:30? All right, so I will do a scheduling order. I'd rather keep it open than make you guys go and file it again. So I will do a scheduling order, setting a pretrial for June 3rd, 24 at 1:30 p.m. And anything else, Mr. Goldsmith, Mr. Landry, and Mr. Lucas?
No, Your Honor.
No,
Not for
no,
me.
thank you. Thank you
you,
for
Judge.
hearing us, Judge.